aren't we?
Yes.
Yep, good. Good to go. Hi, Phil Brunner here again from Bailiwick Legal, doing another one of these Facebook live recordings. Hopefully getting a little used to these and not finding them too difficult. As I said, hopefully. Still a bit nervous doing these things, trying to prepare. You're about to embark on can be a little time consuming and difficult from time to time, but anyway, let's give it a go. So, usual disclaimer, the information that I'm going to talk about today is just that. It's information. It's only provided for information purposes. It's not legal advice and shouldn't be relied upon in that context. If you have some issues or concerns or wish to have a chat about the topic today, which is dividing fences, then please just get on the phone to me or one of the team here at Bailiwick Legal. So Bailiwick, we specialise, for those that don't know who we are, we specialise in agribusiness and the tourism sectors. Predominantly work within those sectors, but as is reasonably common for most commercial-based law firms, we do act in other industries for a range of clients that come to us by referral. So we typically deal with most commercial-based disputes, contractual disputes, constitutional issues, particularly for not-for-profits. We do a lot of work in the not-for-profits area, and property and litigation. So we cover a fair bit of ground within the commercial law space. So let's talk about today's topic, which is dividing fences. And when I first contemplated doing a discussion on this topic, I thought, well, it's topical to a degree. Usually arises because someone has a dispute. Now, that dispute may not actually be in relation to the dividing fence. It might actually be completely unrelated to the fence at all. It might be, and we've had calls about this, it might be overhanging trees. It might be trees that are interfering with a fence. It might be that the neighbour's not being particularly helpful. It might be that animals are getting through the fence. Typically sheep and cattle jumping or pushing fences over. Those things are sort of the typical scenarios that we get calls and deal with issues about. So, as I said, the dividing fences issue is not necessarily one that sort of springs to most people's minds as an issue that creates lots of disputes. And typically there aren't lots of disputes. Most people are reasonably take a reasonable attitude to dividing fences and have orderly and constructive discussions with their neighbours about dividing fences and the repair and replacement. Sometimes, though, those discussions either don't happen or don't amount to anything, or there's another underlying dispute where the parties naturally ultimately get around to the issue being the fence. So I thought, in the context of today's discussion, out the parameters of the legal aspects of particular topics. Today I thought, well, let's deal with this a little differently. Let's deal with through some real disputes that we've actually dealt with in the context of dividing fences. And so that gives you a bit of an idea, hopefully, of the things that can give rise to an issue around a dividing fence, and how to actually try and then deal with those issues. So, sticking with the agricultural theme, I'm going to stick with that theme in my discussion. Right? So the examples I bring forth, other than from matters that we've actually dealt with in relation to clients that have come from the agricultural sector. So the first one is a matter, and I'm not going to name names, so we have an obligation of confidentiality, obviously. I'm simply going to describe circumstances to you. The first one we'll deal with is a matter which we've recently dealt with. We've managed to get the parties to reach consensus about a replacement and construction of a dividing fence. The genesis of the dispute, though, arose, as I indicated earlier, not because anyone thought they had an issue with the dividing fence, but because one of the neighbours got his or her lawyer to actually write to our client, who ended up being the entity being our client, and making demands about reparation of land and compensation for the spread of noxious weed through their crop. Our client was obviously quite concerned to receive a letter from a law firm, really quite shocked at the attitude and the demands made, and came to us to seek advice. We looked at the situation, and it was pretty obvious and plain to us that the issue about weeds was really a non-event, and that the main cause of concern for the neighbour seemed to centre around the fact that there was a need for the fence to be repaired, and for the fence line itself to be cleared up. Often there's lots of rubble left along a fence line, and sometimes fire breaks are not maintained. Sometimes fire breaks aren't actually on the fence line either. So there might be some vegetation growth that interacts and affects the fence. And that was sort of a bit of the situation here. In these circumstances, we actually had a fair whack of territory where the fence wasn't even on the boundary between the properties. The fence was quite a distance in, and quite a distance. I said 30 metres. Now, ordinarily, you would say in those circumstances that, well, how can it be a dividing fence? It's 30 metres into that person's property. But the act itself and the general principle is that if the fence serves as a boundary between two properties, ipso facto, it's a dividing fence. And that's the situation we had here. Now, the neighbour put the fence 30 or so metres into the neighbour's land, not through any sort of sinister reason, but just because the bush was there. All right, so maybe that's being a bit lazy. Didn't really want to drive the grader through the bush and put a channel through there because of trees, rubble, granite, dirt, whatever. But decided to just take the fence around the bush itself, and no doubt that that's something that happens a reasonable amount within the agricultural sector. So we have a situation then where the initiation of the dispute really was for reasons that had little bearing on the dividing fence itself, but the reality was the dividing fence was the real issue in dispute ultimately. So in those circumstances, our advice to our client was to seek to engage with the neighbour for the purposes of seeing if an agreement could be reached about constructing a fence on the boundary, and in the context of some of the fence line that was already on the boundary, for repairing that. And we're talking, typically we're talking long distances here. This is not a suburban fence that might be 40 metres long. These are typically fences that are usually kilometres long. And there's a cost, obviously, cost structure associated with the length of that fence, and putting a new fence in, which is usually in excess of what you'd find in a residential context as well. So, as I said, our advice was to approach this on the basis of seeking to obtain an agreement with the neighbour on the structure of a new fence, what it was to be made from, who was to get the materials, who was to do the work about putting the new fence in. So there's a raft of issues to actually talk about. Now, the advice we gave to our client was to actually formalise that request to the neighbour in a form which would then allow our client, if agreement couldn't be reached, to actually take that matter then to the Magistrates Court, which is the secondary step under the Dividing Fences Act. If you can't get agreement, you can actually take the dispute then to the Magistrates Court, have the Magistrates Court issue an order that the fence be repaired or replaced, and also seek orders from the court about who's to cover the cost. Now, typically, invariably, in fact, in almost all cases, the cost is going to be split 50-50. Now, that will be a different separation of costs where there has been deliberate damage done to a fence by one party, but they're sort of the aberrations. They're not normal issues. So we did this. We put that proposition to the neighbour, and I think in the end we probably had probably 4 or 5 pieces of correspondence back and forth over, unfortunately, probably a good 6 months before we finally reached an accord with the neighbour about putting a new fence in and repairing part of the existing fence that was there. So a good outcome. Took a little bit of time, took a little bit of energy, but at the end of the day, the parties have reached a settlement in the context of putting a new fence in and who's to do that work. And in that circumstance, the agreement reached between them was that one party would do a particular section of fencing, the other party would do the other section of fencing. They would get the materials themselves and sort it all out. So it was really sort of taking half and half, rather than getting a contractor in to do the whole fence and then splitting the cost. The neighbours were prepared to actually do the work themselves and bear the cost of actually getting the products necessary independently of each other as well. And that's fine. That's all good and well. Problem solved. All right. Bit of time taken, but at the end of the day, the parties reached an agreement. And by and large, in our experience, that is generally what happens. The parties will ultimately reach an agreement on the replacement or repair. As I said, if that's not possible though, an avenue then available to either neighbour is to take the dispute to the Magistrates Court, the local Magistrates Court, who would then determine the style of fence, who's to do the work, and the cost and the sharing of that cost. Of course, going to the Magistrates Court is a cost in itself. It's not a process we would logically recommend, but if you're in that environment, try and make the most of it. So the second example I wanted to talk about, in our view, for our client at least, we consider it to relate to a dividing fence. We have a situation where our client, who is a farmer, has a property in Perth, and that's not uncommon. And the neighbour, we're talking about residential property in Perth, so the neighbour wished to build a new house on their land next door to our client's house. And through the course of that process, the neighbour obtained a design for their new house, which did not take into account the width of a dividing wall. So between the two properties, at the front, a long limestone wall. And this is actually a pretty thick wall. It's about 40 centimetres thick, so 400 millimetres thick, and about 1.6 metres high. So it's a pretty substantial structure. And it sits on the cadastral boundary, so it serves as a dividing fence, or a portion of the dividing fence between those two properties. Now, it does butt into, if you like, the neighbour's land by 30 odd centimetres. And when the neighbour's designing their new house, they ignored the fact that the wall was there, designed the house so that they would have the requisite metre between the cadastral boundary and the side of their house. But then obviously there's a problem after the build. If the wall's to remain, that passage would be then limited to about 6 or 70 centimetres. So the neighbour, in its wisdom, decided that rather than approach our client to have a discussion about what to do about this problem they've got, decided that they would seek an order under the Building Act to have the wall removed. Now, that brings in another problem, of course, because we've got a different piece of legislation. This is a boundary wall. It's a dividing fence. Ordinarily, you'd think it would fall within the Dividing Fences Act and within the parameters of that act. But the Building Act does allow for dividing fences to be removed in particular circumstances. Now, we don't think the circumstances in this situation really are alive, but of course the neighbour's got a problem about that width of the passageway. Their problem, they made the problem, but at the end of the day they've asked the court to remove that problem for them. So why this example? This is an example to let you know that just because it's a dividing fence doesn't necessarily mean it's always going to be dealt with under the Dividing Fences Act. The Building Act has provisions to deal with dividing fences and the removal of those fences in particular circumstances, as I said. Now, I would hazard a guess that this is an issue that would only arise in a residential context. For those farmers that have residential premises either in Perth or another place, mostly along the coast somewhere, that's an issue that they might need to take consideration of. Firstly, if they're looking to actually demolish and rebuild a house on those premises and they don't like the look of their dividing fence, or they've got a neighbour in that environment who might try the same approach. So again, a bit of a quirk within what the law looks at and how the law might work in the context of a fence that sits on the boundary. So the third issue is one which probably comes up very infrequently. It'd be a rarity, and I say that because we've only dealt with one of these situations, and that's a situation dealing with a strata title. So again, this is a residential Perth-based issue, and the dispute arose again not because of any issue about the dividing fence, but because one of the people residing in one of the units, and I think it was a 3-unit complex. Our client's unit was at the very back, and I think the people who occupied the second unit would park their cars down the driveway, and they would block access to our client's unit. And so, that throws up an issue about, one, access, two, whether you can actually put a wall in to safeguard your courtyard and your what you perceive to be your property. I don't know whether anyone's familiar with strata titles. They're quite a different beast in the property context. Not an easy situation to deal with ordinarily, because in a strata title, typically you've got what is known as common land. And so you will typically own what's inside your unit, depending on the type of strata it is, but there will be what's known as common property, which effectively is property shared amongst all owners. And in this 3-unit complex, the driveway and everything down to the front door of our client's unit was in fact common property. So the fact that they'd actually put a wall in and a gate to separate a courtyard, that wall and gate was on common property. And so you got to deal with the dispute not in the context of trying to get access, but in trying to make sure that access. Sorry, I probably said the wrong thing there. The dispute then is to try and make sure you get access to your unit, and wasn't necessarily dealing with the dividing wall at all. But through the course of that, and the reason I raise this, through the course of dealing with that dispute, we determined that the owner, our client, hadn't actually got permission from the body corporate to put that wall and gate in the first place. And that creates a bit of a problem when you're trying to enforce other rights, where you've actually done something wrong yourself. So, long story short, I guess the client ultimately resolved the issues about access and the blockage of access, and so that issue then sort of blew over. So there's sort of 3 examples of how dividing fence issues can arise and disputes arise. I haven't talked typically about the Act itself. I didn't really want to get into the legal aspect of it. In a very general context, the scheme of the Act is talk to your neighbour, try and get an agreement about the repair or replacement of the dividing fence. The policy behind the Act is to generate conversation between the parties so that there is an amicable agreement reached. As I said earlier, the typical approach and what the Act is designed to achieve is a cost profile that each party bear 50%. So when you're looking to enter into discussions with your neighbour about replacement or repair of dividing boundary fence, you need to understand that you're going to be up for 50% of the cost of that from the get-go. I guess the other important aspect here is the type of fence, because some people get a bit hooked up on this. They want the sort of flash fence rather than the fence that will just serve the purpose of a fence. In an agricultural sense, perhaps the easiest way to explain this is that where you're simply cropping and that's all you do, and that's all your neighbours do, then conceptually you don't actually need a fence. And if you were to have a fence, it doesn't need to be anything of any great substance. It could probably be, probably only 3 foot high and maybe 3 or 4 strings. But if you're in an environment where people have animals around you, like sheep or cattle, then you're going to need a different style and type of fence. And sometimes you'll need to have electric strands on that fence as well. So in the context of a dividing fence, if you're going to have it electrified, is that both sides, or is that one side, or is that on the top? How is that to actually occur? So there are those issues you would need to talk through with your neighbour. The base principle is what they call a sufficient fence. It's got to tie in with what is typically around you. In a residential context, that's often sometimes a little different, and it probably depends on which suburb you live in more than anything else. In a rural context, it will depend, as I said, on what's the activities immediately around you that you need to be conscious of. And the sufficiency point is also relevant from the point of view of what the purpose of the fence is for. The fence is not necessarily there to look good. Invariably, it's there for a purpose, to act as a boundary delineation. So, and the other thing that the fence is the purpose of the fence in an agricultural setting is to keep animals in and keep animals out. So you've got some prime purposes there you need to be conscious of when you're actually looking at repairing or replacing a fence. Okay, I think I've rabbited on enough this afternoon, and I'm hoping that you've got something out of that. As I said, it's a little different approach. I thought we'd mix it up a bit and actually give you some real example, a couple of examples of what we've actually dealt with. So there's a bit of an understanding of how the law might work in relation to certain disputes. Happy to have feedback on that. If you like that approach, let me know. If you don't like that approach, let me know. Happy to take some feedback and constructive criticism in relation to that. Okay. As always, Bailiwick, we like to provide advice based on a common sense approach and to obtain practical and real outcomes for clients in relation to disputes they might have. We do have a fairly experienced team here to deal with issues and the work that flows in. So in the context of today's discussion or any other issue you may have, feel free to reach out to me or any of the other members of the team. We do undertake consults, to sort of 30-45 minutes or so for free, and if that helps to put your mind at rest, that'll be great. So call me if you need. And thanks everybody, and enjoy your afternoon. Cheers.